Hello everyone, so welcome to my English Law channel. So this talk is going to be about the Doctrine of Precedent and how cases are analysed. So by the end of the session, ideally, you will grasp what the Doctrine of Precedent is and its role in the common law system. You will know what the hierarchy of the courts is, and you will be able to pick out what are the binding parts of a judgment. You will also know what elements of a case are persuasive rather than binding. You will be aware where you can locate case law, and you'll be able to break down cases. So anyway, there is common law and there's civil law. So common law largely started off in England. It's not completely original to England. It does owe something to some sort of Anglo-Saxon traditions that the Anglo-Saxons brought over from the continent. But anyway, common law spread to Wales. Later we got it in Ireland, and then Scotland is somewhat common law, but a bit more civil law, i.e. Roman. So when the British Empire expanded across the globe, that's why common law travelled the seven seas, and you'll find the common law in the Antipodes, in Zimbabwe, in Canada, Malaysia, Nigeria. I shan't name all the jurisdictions. To some extent, Israel. Anyway, so one of the key principles here is stare decisis, as in stand by the decision, trying to keep things consistent. Because it'd be unfair, because she was found guilty in this situation, but he was found not guilty in exactly the same situation. I mean, what is the decision? That's why you have to say there's going to be consistency. We often talk about the doctrine of precedent. What's gone before? What did courts decide in a like situation earlier? All right, we'll stay with this, unless there's a very good reason not to. So judges will follow the decisions of other judges. Now, there's Roman law, sometimes called civil law, which you'll find on the continent, which you find in France, Spain, Portugal, and so forth, and their erstwhile colonies. So, all the countries from, say, Portugal to Russia, roughly speaking, are common law countries. So these have legal codes, and they have procedural law. So the decisions of earlier judges are persuasive, however, they're not binding. Now, as I said, Scotland is partly Roman law, partly civil law, and the terminology used in Scotland is different from England and Wales. But anyway, this is the English Law channel, so we're primarily interested in England. Curiously, the Republic of Ireland, our law is more similar to English law than it is to Scots law. In Canada, because they got Quebec, that former French colony, they got a bit of Roman law there. Or the United States, it's only Louisiana which has got Roman law because it's a former French colony. Okay, so what is the doctrine of precedent? And here it says that the pertinent part of a case is binding, and that's if the earlier case had been decided in the court, so the decisions which bind the court bind others, right, when the case is heard later on, or similar case heard later on. So there's a hierarchy. So you start at the bottom in county courts for civil matters, magistrates' courts for criminal matters, there are various employment tribunals and so on. Then the appeals can go up to the High Court, or if it's a criminal case, the Crown Court. If it was very serious, it could start in the High Court or the Crown Court. If it's a crime which would attract a sentence of more than 2 years, it would start in the Crown Court. If it was a case involving a huge amount of money or something, it would start in the High Court. And then if people can appeal up to the Court of Appeal, it's got 2 divisions, civil division, criminal division, and then they could even appeal to the Supreme Court. It was called the House of Lords till about 12 years ago. Certain human rights issues can be referred by the Supreme Court to the European Convention on Human Rights. Yes, the UK is out of the European Union, but the UK is still a signatory to the European Convention on Human Rights. But by the way, you don't take your case to Europe. The Supreme Court might choose to refer it, and then there we go. Once you've exhausted all domestic remedies, but that's very rare these days, especially as the European Convention on Human Rights has been domesticated into British law. So these courts they're called tiers, not as in lacrimating, but Tiers. A bit like tierce, a third in French, even though they're 4 levels. But never mind. So criminal courts, there's Magistrates' Court, up to Crown Court, up to Court of Appeal, up to Supreme Court. So doctrine of precedent. So the higher courts bind the lower courts. Logically enough, the Supreme Court can bind the Court of Appeal, which can bind the High Court in the Civil Division, down to binding the County Court. Or the Supreme Court in Criminal Division binds the Court of Appeal Criminal Division, which binds the Crown Court, which binds the Magistrates' Court. Well, there's a certain logic to that. There's also the Judicial Committee of the Privy Council. There's Wilkers against Joyce and others, number 2, 2006. And it found that the Judicial Committee of the Privy Council is persuasive only. We often say the Privy Council for short, even when talking about the Judicial Committee of the Privy Council, which is judges. The Privy Council is something different, and that's for all ex-cabinet ministers, sometimes former leader of the opposition or current leader of the opposition, those who have the handle the Right Honourable. They're Privy Councillors, as privy meaning like private. They never actually get together with the Queen, or hundreds of them, and meet. But there is a Privy Council meeting once a week with the Queen, but only about 2 cabinet ministers go. Now, in extraordinary circumstances, the Privy Council could overturn a decision of the Supreme Court or the House of Lords, right, and become binding. So courts are bound by earlier decisions. There's a practice statement. This is Judgment, Judicial Decision as Authority, House of Lords, 1966. So the House of Lords said that it can go against earlier decisions. Now I have the Supreme Court. That is obviously applicable to the Supreme Court, which is the new edition of the House of Lords. So courts, are they bound by early decisions? Well, in the Court of Appeal they are. Young against Bristol Aeroplane Company, 1944, said it was found that if there are conflicting decisions of the Court of Appeal and the decision has been implicitly overruled by the House of Lords of the Supreme Court, yes, it can be. Or if the decision is per incuriam. The Criminal Division, R against Taylor, was a case where this was discovered. So a person's freedom was at stake. So they said, yes, in very rare circumstances they can be. So coming to the High Court, previous decisions aren't binding in the High Court of the High Court itself. They are persuasive though. So let's look at law reporting. And law reports are published by these independent organisations, not by the courts themselves. There's the Incorporated Council of Law Reporting, ICLR. They're the AL-ER, as in the All England Law Reports, a very useful source. There's certain specialist reports like family law reports, for example, or appellate court. So there are lots of things online. You can find, the Supreme Court's own site, British and Irish Legal Information Institute. Look at that one. Lawtel, LexisNexis, as in network of the law in Latin. Westlaw. There are many more. So let's look through some of the lexis then. So there's stare decisis, stand by the decision, as we know. Ratio decidendi, as in reason for deciding. The judge will give that at the end of his judgment. And and if you want a plural, it's rationes decidendi. Often we just write rationes. Some people pronounce it rationes. There's obiter dictum, other things which are said in reaching the conclusion, but they're not part of the ratio. So obiter dicta, that's when it's pluralized. The material facts is in the facts which are pertinent to the case. We don't want things which are immaterial. They're just called surplusage. Res judicata. That is a decision which the parties have made, which is binding on them, that the court didn't make. There's per incuriam. That's through not caring, not being careful enough. Okay, so the judge can be found to have erred in law. So sometimes decisions are affirmed where the court said, yes, the early decision of the lower court was correct in this appeal, reversed, decision in the lower court referred to a higher court, and the higher court overrules that decision and said you got it wrong. So either affirmed or reversed. Or they often say the Supreme Court allow the appeal, as in the appellants win. They deny the appeal, so the appellants lose. Applied is when a court thinks a case establishes a precedent and it follows legal reasoning. Approved is when a court says the legal reasoning in that case was correct. Considered, as in when the case is debated in court. Disapproved is when the court says that we're not going to go along with the rule in that case, but we're not going to overrule it either. This might diminish the doctrine of precedent. Distinguished. This is when a court says, yes, but that situation is not the same as this situation. This is the difference, and that's why we're deciding it differently. Overruled is when a court says that decision in the earlier case is wrong, and we're changing our own precedent. The Supreme Court can say that precedent we set 100 years ago is wrong. Things have changed. So they're parties to an action. Remember, in civil law, the claimant is the one who's claiming money. We used to call him the plaintiff. I suppose he was plaintive, as he was crying. But this plangent person is still called a plaintiff in the United States. The defendant is someone who's saying, no, I'm not in the wrong, I'm not going to pay compensation. The appellant is someone who's appealing. And there's a defendant, or sometimes say the respondent, who's defending in an appeal case. So in criminal law, the prosecutor argues someone's guilty. The defendant is the person who's accused of the crime. Obviously, the defense lawyers are arguing the defendant is not guilty. So we in civil cases, it'll say Bolton and others against Stone, for instance. The V is read as against. So we sometimes have as others, or have, our criminal cases could be R against Bien, R meaning Regina, as in the Queen, Regina, some people pronounce it, or in the old days, Rex, the King. Sometimes we even said the Crown against whoever. There was the Chief Constable of Somerset and Avon against Shimon, and there are many more criminal cases. So sometimes we have to have confidentiality, R against B, because the person's a minor or whatever, or it might be a rape case. Array A, conjoined twins. There was baby P in cases like that. So there's judicial review. Like before 2001, it was R against Medical Appeal Tribunal ex parte Gilmore. But since 2001, it'll be R on the application of the CC of Manchester Police against Halford Magistrates Court. So now we say on application of not ex parte. So anyway, there was an important case, Rabone and another against Pennine NHS Trust, a Supreme Court case in 2012, and then that's the year of decision. And a law report would say the names of the judges who sat on it, and it'll set out the material facts. It'll refer to what statute is relevant here, and then we'll say what was held, what did the court actually decide, this is what they decided, that's why they decided, and things like that. And they mention the case they refer to in the judgment. Okay, so it'll break down the crucial elements of the judgment, summary of the facts of the case, usually at the outset, the legal reasoning he's using, use the obiter dicta, as in various remarks made in the coming to the judgment, but are not actually binding, and the res judicata, which would be right at the end. So the binding part of it is the ratio decitendi, and that's the key decision in the case. Right, Donoghue and Stevenson, obviously a leading case, and Lord Atkinson said in that one, you must take reasonable care to avoid acts or omissions which you can reasonably foresee would likely injure your neighbour. Who, then, in law, is my neighbour? The answer seems to be persons who are closely and directly affected by my act, and that I ought to reasonably have in my contemplation so as being affected when I'm direct my mind to the acts or omissions which are called into question. Close quotation. Notice he used reasonable or reasonably 3 times in just those few sentences, and that was a seismic shift in law. Who's my neighbour? Am I my brother's keeper? Well, really anyone impacted by my deeds or failures to act are my neighbour. All those people are my neighbours. So what was the ratio there? The decomposed snail found at the ginger beer bottled. It was negligently bottled, caused gastroenteritis to this customer. Okay, so that's the particular case. But the more general ratio is any defect in any product that's consumable or usable, caused by any negligence, which occasions injury of any nature, affecting any consumer. Yeah, you're liable for that. So, but what was crucial here is the opacity of the bottle. She couldn't see in. It wasn't translucent. It didn't matter that it was a drink, it could have been food. The principle would have been the same. There was grant against Australian knitting mills, 1936. A man bought these trousers, something wrong with them, chemical in the material called them terrible itches in his legs. Had to take a holiday to New Zealand to recover. So, anyway, doesn't matter, it wasn't consumed as a product. Home Office against Dorset Yacht Club, 1970 was like that. So, anyway, there are different decisions. For instance, the Protection from Harassment Act 1997 said Section a person mustn't pursue a course of conduct which amounts harassment to another. However, there was a case where a defendant had been making phone calls and saying nothing, just being on the line. So, how many phone calls do you need to make it a course of conduct? The medieval maxim was twice makes a habit. But one judge says it's 2 is enough, another says it has to be 10, another says it has to be 5. So what's the ratio here? It was unclear. But coming back to that Rabone and another against Pennine Healthcare Trusts, They had to decide whether there's an obligation under Article 2, whether that is owed to a mentally ill patient who's not detained under the Mental Health Act. And if yes, there was an obligation owed, was there a real and immediate risk to the patient? And did the trust know about this? Did they take reasonable steps to avoid harm arising? Were Mr. and Mrs. Rabone victims, according to Article 34 of the Convention? And if yes, had they lost their victim status because the trust had acknowledged its breach of duty and compensated them? If no, were their claim of compensation, was it time barred or not? And was the Court of Appeal wrong in saying that they would have given them £5,000 in compensation each if the claims had been proven? So what's not binding? Decisions about the facts are not binding. The obiter dicta are not binding. And then you've got to decide whether something's a question of law or a question of fact. Okay, whether the obligation was owed under Article 2 is owed to a hospital patient who's mentally ill, even if not detained under the Mental Health Act. That's a question of law, and so on. Whether was there a real and immediate risk to the patient in that case? You see, that's a question of fact, and so forth. So obiter dicta is things which are said as an aside, really, that they're not so crucial. And the case doesn't turn on the obiter dicta. So the Protection and Harassment Act, 1997, come back to a case about that. So the question was, how many phone calls is a course of conduct? So the judges might think that 3 will be sufficient, but that would be a proposition of law. But it's obiter dicta, it's not a ratio. So remember, the pertinent part of the case is binding. If an earlier case has been decided in court, the decisions of that court are binding. So remember, persuasive cases about Stevenson and Donoghue. Donoghue and Stevenson was Grant against Australian Knitting Mills, 1932. Donoghue and Stevenson, 1936, and it binds all Commonwealth jurisdictions. There are other jurisdictions like Fairchild against Glenhaven Funeral Services, 2002, and in that case they looked at the cases from 13 jurisdictions. So these cases are binding on lower courts. Obiter dicta are not binding. We sometimes cite a dissenting judgment, as in a judge disagrees with the majority. Still worth hearing what he or she's got to say. So I hope you've got some idea what the doctrine of precedent is like in the common law system, and understand the hierarchy of the courts, and are able to spot what are the binding elements and the non-binding elements of judgment. And you can see what's persuasive, what's not. You know where to find the law, and you can break down a case law's anatomy. Toodaloo.